Hello, everyone, and welcome back to another live stream with me, Grizzly K. This is Grizzly True Crime, and today we are back to discuss the Idaho case, especially in the context of the gag order being lifted. We watched a hearing yesterday. If you missed that hearing that we watched together, then I have put it on the playlist for you. I've linked the playlist below for you. You can find it over there. And I just saw all of your comments, and I thought, you know what? We need to phone up right now. And who better to call than Josh Ritter, a highly experienced attorney based in Los Angeles. And he's the host of Courtroom Confidential. And I know many of you know about the channel already. If you don't, I really hope that you will check out his channel. Here it is, Courtroom Confidential. You can even submit voice notes for Sunday Funday that they have over there on their channel. And it's really fun to listen to everyone's voice notes, especially seeing familiar faces over here. I like hearing what you guys have to ask over there. So if you haven't yet, go check it out. So today, we're going to be discussing the lifting of the gag order. What does it mean? Can Bryan Kohberger still, change his plea? Can he appeal things? And what can he appeal, right? So we're going to talk to a lawyer because I don't know the answers to all of that. So here's Josh. Welcome.
Thank you so much. Very good to see you. I'm glad that we could make this work at a time that it's not the middle of the night for either one of us.
Right, because usually it is. I'm usually in your chat, 2 in the morning, and I don't know when you're in my chat, but this is a very decent hour. I think it's 9 in the morning for you and 6 p.m. for me if everyone's watching live with us right now.
Look at us, like normal people.
Yeah, like normal people, not like true crimers in the night, looking at all sorts of things. So thank you so much. I know that you have an extremely busy schedule. You're in demand, and I'm just always so honored to have you here with us.
Oh, please. I'm honored to be here.
All right. So what did you think of the gag order being lifted as a general question to warm us all up?
I thought it was great. I thought it was about time. I was surprised that there was even an objection to lifting it it was funny because originally it sounded like, and the judge even said that in his comments, that he was ready to lift it at the time he took the plea. And then the prosecution was the one who originally pushed back and said they didn't want to lift it. Then they withdrew their objection to it, and the defense objected to it. So I don't quite understand. I think it's a little bit too much hand-wringing on everyone's part to be concerned about it now because he has taken a plea. The whole concern with the gag order was to protect the public and, more importantly, potential jurors from learning too much information that it might prejudice them and make it just too difficult to find an unbiased jury. I will say gag orders are not unheard of. They're sometimes more common in cases of this kind of high profile, especially when you're dealing with smaller communities. Boise is a much larger, where they moved it to the county, Ada County is a much larger county. So it wasn't as big as a concern, but when it was back in Moscow, it was a bigger concern. But even the order that they had in place here was very, very strict. It extended beyond, it extended to the victims and the witnesses and their lawyers. And it was like no one could talk about this at all. And I think it just really led to, there's the order there. It just included like everybody. And it led to a lot of, I think, unnecessary suspicion that turned into a little bit of speculation that then turned into conspiracy theories. And we probably could have avoided a lot of that had it not been so strict from so early on. But here we are. I'm glad that he lifted it, and I think it's a good thing.
Right. So before I play some clips, that is actually one of the questions before we dive into all of it. What is the purpose of a non-dissemination order? I think you just answered that. And who exactly did it affect in this case?
Yeah, so usually, in I've been involved in many cases where the judge, if it's a media, quote unquote, media case, the judge will say, listen, be careful about what you say. I don't want there to be trouble. I don't want there, you're all adults. Watch what you say to the media. I don't want there being problems. And usually attorneys know what that means. They can kind of comment on it. They can say to the media, our client is looking forward to proving his innocence in court, and you hear all these kinds of things. But the judge here was like, I don't even want you talking to the media, which is very strict. And then he extended it to not only the parties involved, the prosecution and the defense, then he extended it to the witnesses, the victim's family, the attorneys acting on behalf of each of those people. So it was just anyone and everyone who was even tangentially connected to the case couldn't talk about it. And it just led to everybody, anytime we would get the tiniest bit of information, we would all run around trying to figure out what that meant and how important it was. And, it led to a lot of, like I said, conspiracy and speculation, but they were very concerned with the media attention in this case. You remember it was originally in Moscow and they moved it all the way to Boise because of the media attention. And I think that is kind of the result of, one, you have a case that's, I don't think it's overstating it to say this probably, if it had gone to trial, probably would have been one of the bigger trials of the decade, honestly. I mean, you're talking about 4 college kids stabbed to death in the middle of the night. That's just unheard of, nightmarish type stuff. And then you've got this defendant who has no criminal record. I mean, it's not like he's some violent person that this was bound to, he's living this life with going to get his doctorate degree, a criminology student, like everything about it just made for why it would get so much media attention. And then you add that to a smaller community like Moscow. I've not been there, but every person I've spoken to who's been there says it's just a very kind of tightly knit, smaller college community. And so it just enveloped that community. And so they were concerned about how would that affect the potential jury pool there. And then it just extended beyond when they even moved it down to Boise. They just kept that order in place. So again, good thing that they're allowing it to lift it, especially so that now that the victims' families can finally feel free to speak about this case more.
Yes. So I'm going to play some clips from Steve Goncalves from his most recent interviews since yesterday, since the gag order was lifted as well. I think the fascinating thing about this case as well was the time from when the killer entered the home and left the home. That was like shocking to everyone. I mean, a quadruple homicide, in, out, off their speed, like what is going on there? And then to arrest a guy getting his PhD in criminal justice, really? I mean, as you said, I think this would have been the biggest trial of the century. So yeah, I do think this is his way of taking control, isn't it? In fact, check out this clip. By the way, everyone, feel free to ask your questions. I'm going to star them if I can, like Kraken's one, and I'm going to get to them afterwards. Okay, I've got a couple of just basic questions to ask Josh here. I think there are about 5 or 6 of my questions, and then which I got from all the comments section that you guys were asking from yesterday, and then I'll get to your questions. So I think let's play this clip here quickly.
He wants to be able to have that final say of how this is going to end, and that's part of the reason why we would have asked for them to make some negotiations and made him prove where the weapon was or the kill kit, all these details, because those are the details that the conspiracy theorists would have to be like, okay, it's over, it's done.
Okay, we're going to look at that hearing as well, that clip from there. But shame. I mean, that is actually true as well. Imagine the families don't know. Well, where's the weapon that killed our kids? What is happening? They don't know all that information yet. So this helps them too.
Yeah, and that's a really excellent point that Steve makes, because it's not just about them getting answers, which I was very frustrated by that as well. I thought that this plea offer was actually a good offer, and I know a lot of people are upset about it, but when you look at what the prosecution gained compared to what they actually gave up, I think end of the day, it's a good offer. But the one part that really frustrated me is what he just explained there is why did it include some sort of proffer from Bryan Kohberger so that we could get a lot of these answers? And one reason for that is for the families. They want to know. They want to know, why was this house targeted? Who was he coming after? Why? What brought them on his radar? And all of these types of questions. But then he makes the point too, there's this weird contingency of people who just still have conspiracy theories about who was involved and whether or not it was Bryan Kohberger. And it might have put a lot of that to rest just to give the family some peace. When the prosecutor was in court when was it, a week or so ago, for the change of plea, he made that statement in court. You remember, he kind of gave almost like an opening statement about everything that the prosecution was aware of and what they intended to prove. But it was so remarkable and frustrating to me how much he admitted they didn't know. And one of the things he said was, you know, the knife has still not been located. We don't know where it is. And I'm sitting there going, well, the guy who knows is sitting 12 feet away from you. Why are we even asking these questions? Like, that should have been a part of it. And I don't understand why it wasn't. And it sounds like the family even asked the prosecutors to make that a part of the plea deal. And the fact that it wasn't is, I think, a real shame.
Yes, so sorry, I didn't mention for people who don't know, I'm pretty sure everyone here knows, but Steve Goncalves and Christy, they are the parents of one of the victims, Kaylee Goncalves. 4 students were murdered on November 13th of 2022 in Moscow, Idaho, and that's the case we're discussing with this gag order being lifted. So in that context, what exactly does lifting the gag order mean? Like,
right.
Who can talk now? What does it mean? What information will come out?
Right. Yeah, if you're all thinking that all of a sudden we're going to get this flood of information, that we're going to get a bunch of crime scene photos and interview tapes and things like that, it's not going to happen. And if it does happen, it's not going to happen for some time. So I know that's a little disappointing. What this really does is it just removes the restriction for everyone that we just talked about from being able to talk about it. So, you know, the Goncalves family, all of the other families, the Mogen family, the Kernodle family, the Chapin family, they can all speak freely about this. All the witnesses can speak freely about it. Law enforcement can speak freely about it. So can the prosecution and defense, but it's still their choice. And both the prosecution and defense have already indicated that they intend to make no statements or interviews about this. So we're probably not going to be hearing from them, which makes me think we're probably not going to be hearing from law enforcement as well, which is frustrating. So it's just the restriction on speaking to the media has been lifted. And then I know you want to get into this later. Also discussed was the sealed documents. And he talked about removing the sealing order on some of those documents. And we can get into that now or later, but I'll tell you how that's a little bit different from the removal of the gag order and what that means.
Let's play the clip and then we dive into that. So here's what the judge said.
To lift the non-dissemination order. Obviously, nobody's required to speak to the media, first of all. Second of all, I want to...
Let me just pause and say, yes, everyone, I zoomed into Kohberger for you. You like that? I don't like it. But I'm like, okay, let's just look at him a little closer. Okay.
Be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist.
I'm going to pause it there already. What is he referring to there?
Well, a preservation order usually has to do with the destruction of evidence. So they will send out orders to, you know, you see it most commonly in stuff with dealing with surveillance cameras. So if there are, you know, they had a lot of surveillance cameras in this case, and they gave orders to each of those either companies, you know, if it was a part of a company or a gas station or whatever, some business, or even residents, that they're not to destroy that evidence, that they're to preserve it in case it needs to become used at trial. And I think what he's saying is that lifting of the gag order doesn't affect that at all. But that's my belief is what he's referring to there.
Okay, I know everybody has, we're going to get to, let me give you a cheat sheet of the questions. What exactly was his plea deal? What exactly can he appeal? Because we're all worried about that. I know everybody's like, what? So we're getting to that. Right now, we're quickly going to discuss the sealed documents part. So I'm going to finish playing the judges. This is a very short clip. I've put together a little compilation, and it's got some media parts as well. So it's less than 5 minutes. But let's just play about 2 minutes of it here while the judge talks about that.
The other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of.
That was actually a huge statement. Let's first just deal
then
with the sealed
Everybody lit
documents
their hair
part.
on fire
Yeah.
the second he said that. But yeah, we'll get
All
into
of us
it.
were like, wait, what is he saying? Why is he saying the word appeal?
Right.
First, the
right.
sealed documents, then we'll go to what on earth that means. Okay, so
Right.
what exactly is, well, do you know what's
So-
being sealed and what could be unsealed and how long that could take?
So many of the motions that have been filed in this case have been under seal, including whatever exhibits are attached to those motions have been filed under seal, meaning usually you file a motion in court, that becomes public record, and that can be, released to the media and everybody else who asked for it. But here, because there were certain concerns about information, concerns about the evidence, there was that non-dissemination order in place. They were much more strict as to about what things were under seal and what wasn't. What he's saying is that the lifting of the non-dissemination order, the gag order, has nothing to do with the sealing orders. But he is going to address all the sealed documents and unseal those documents as he sees fit. But like you just heard, that's not going to happen until sometime, probably weeks or months down the road, which is unfortunate. But it's important to understand the difference between the sealed documents that are in the court custody and the evidence. So the court has, for instance, there are some things that I doubt will be unsealed. Most recently, the defense filed that motion for alternate perpetrators. And in that motion, which was filed under seal, they named 4 individuals. We know that, but we don't know who those 4 people are. That will probably remain under seal because there's a privacy concern about those 4 people. They've been named as a suspect. They don't want their names getting out there, the public harassing them, everything else. The judge is probably going to keep something like that sealed or at least redacted. So anything that kind of has this overriding privacy concern, the judge might keep the sealing order in place, which is, again, not extraordinary for this case. That happens in many cases when you're dealing with people's privacy. But that is only the court documents. It's not the evidence. All of the evidence, the crime scene photos, whatever videotape that was done, surveillance videos, interviews, testing, reports, whatever it is, all the evidence that was gathered by law enforcement, that is still in the custody and control of law enforcement. That's not been like handed over to the judge. So the sealing order has nothing to do with that. So if we want to ever get our hands on that stuff, it's going to have to go through the normal mechanisms of making public records requests, FOIA requests, things like that to law enforcement to try to get that. And it's really up to them. And you have some experience with this, whether or not they're going to turn that stuff over. Some things they might, other things they're just going to probably never turn over. The one thing that will be probably revealing, though, in the unsealing of the court documents will probably include exhibit lists. So we might see what it was listed that they intended to use, but it might just be something like, Exhibit A, crime scene photo, Exhibit B, crime scene photo, but it could be more descriptive and give us a better idea of what stuff they had. But I think if people are hoping that all of a sudden we're just going to see this flood of evidence, it's probably not going to happen. And if it does happen, it won't happen for some time.
All right. In many states with FOIA requests, it's only at minimum 30 days after sentencing that you can even make the request, or
Right.
sometimes 90 days. So even just knowing that, and then it's still limited and redacted. So we'll have to wait and see. But we know there's going to be a flood of YouTubers, okay, including myself. Grizzly Cat always helps me, knocking at their door. Excuse me. We would like the body cam of Kohberger from when he asked the cop, would you like to get a cup of coffee after all this is over? I want to see that.
Sure.
What? And just the raid and the search of his parents' house, of his apartment, all of that. We want to see all of it. But anyway,
we probably will get stuff like that because I can't think of a reason why the judge would or the police would say, no, we have an interest in keeping that undisclosed. But if you're looking for body cam footage of the officers who entered the home, probably never going to see those.
Oh, man.
Yeah.
Destroying the
Yeah.
hopes over here. Well,
Yeah,
we're going to
right.
try, right? We're
Oh,
definitely going to
yeah.
try.
Yeah,
All the
make the request, sure. Yeah, everybody's
So
gonna try, yeah.
requests on repeat. Also, the sealed information, the judge had mentioned it could be birth dates, social security numbers, information about minors or victims, protection of individuals, yeah, from undue harassment, like those
Yeah.
4 names. Yeah,
Yeah.
that makes sense. I was thinking, well, who does he mean exactly? Oh, those alternate suspects the defense was going to offer. So, yeah, that kind of thing, it makes sense. That would remain sealed in case anyone gets upset of why. Why would things still be sealed?
Right.
That's why, to protect people and their privacy as
And
well.
it might include even just other witnesses. Like, a good example is the DoorDash driver. Like we know kind of who she is now, but I don't think the judge will unseal all of her information. But the gag order being lifted means that she can go and talk to the media if she wants to. So it's more about these people's freedom to speak than it is about our ability to actually access a lot of that information, if that makes sense.
So anyone who was going to testify at this trial can now speak to the media, right?
Yeah. Yeah.
Okay,
That's
come
what
here.
lifting
And
the
to
gag
you,
order.
right?
Right. I know.
GrizzlyTrueCrime at
Send
gmail.com.
send out an invite. Yeah.
Yeah. Anyone, just contact me. It's all good. You can come here and talk to us. That would be very interesting. Okay, now the big question. We can't make them wait anymore. What can Bryan Kohberger appeal? Based on what the judge said there, that language he used, everybody was freaking out. What does it mean?
Yeah, everybody lost their minds. All right. Well, not to get too much into the weeds. Okay. I'm trying to think about the easiest way to explain this. Anytime you waive a right, it has to be knowingly, voluntarily, and intelligently done. So whether or not that's your right to speak, if you're waiving your Fifth Amendment right to remain silent, your right to counsel, if you want to represent yourself, all of these things have to be done voluntarily, knowingly, and intelligently done, including your right to appeal. So if you're waiving a right to appeal, that has to have those 3 kind of guidelines. And what that protects against is things like that person being lied to, that person being coerced, that person being threatened, and whatever reason they made their plea, it's not appropriate. And so that's more about we see that ineffective assistance to counsel kind of plays into that. If your counsel is not advising you of all of the evidence you have at your disposal before you make your decision, or your counsel is not advising you of all of the consequences of your plea before you enter your plea, then you can go back and withdraw your plea. So part of it is saying, listen, he still has a right to withdraw this or somehow appeal it down the road if it's somehow proven that it was, not willfully, intelligently, given. What did I say? Willfully, knowingly, and intelligently given. That's not going to happen. I mean, if you saw the plea that took place in court, that's why it took so long. And that's why the judge seemed to ask him the same question 4 different ways. It's to avoid any problems dealing with that. But the other thing that's at play here, and that case that he references, it stands for this idea. Just because you waive a right to something doesn't mean you can't attempt to do it. And I think that's the best way of explaining it. Okay. Like what the judge is saying is he can still appeal. And before everybody loses their minds, he could file the paperwork. He could get a notepad out and write out an appeal and put it in an envelope and put a stamp on it and send it to the Court of Appeals in Idaho, and they would receive it and file it. But he would immediately be confronted by the prosecution filing his waiver of appellate rights, and it would be dismissed. So the judge is saying, and what that case Garza stood for was that idea that though you waive your right to appeal, it's not actually prohibiting you from ever attempting to appeal, I guess is the best way of putting it. I hope there's no appellate specialists listening to this who are going to attack me because I'm trying to explain it in the simplest of terms. But
that's what we want. Tell us like we're 5, okay?
Yeah, right. I explain it. I confront situations like this a lot in my practice. Like people try to go and get a protective order, right? They want a restraining order against somebody else because they're being harassed. And they're like, well, I just need it to stop. And I explained to them a lot, well, you know that we can go get you a restraining order, but it's as good as the paper that it's written on. Like, that doesn't stop the person. They could still show up. They could still do whatever they want. I mean, it's kind of my joke about when you have a sign that says this is a gun-free zone. Well, that's only stopping the people who don't want to bring a gun in there, right? Like, it's only if they follow the order itself. Now, if somebody violates a protective order, you can call the police and say, I have a protective order, come out and arrest this person. And it's kind of, maybe I'm doing a tortured metaphor here, but it's kind of the same thing, that he waived his right, but that doesn't mean that he cannot attempt to ever appeal. But if he does, and this does happen, by the way, the prosecution will just immediately file his waiver and it will be dismissed because the court will see that he's essentially entered into a contract. And that's what a plea negotiation, a plea deal is. It's a contract between the defense and the prosecution. He has given up his right to go to trial in order for the prosecution to give up their right to pursue the death penalty. And because that exchange was made, they're going to enforce the terms of that, which included a term that he would not have the ability to appeal. So in the rare circumstance, which is not going to happen, that he can show that somehow he was lied to, threatened, coerced into taking this plea, he does not have the same right to appeal that anybody else would. And that he would, if he had been convicted by a jury, he would immediately appeal. He would appeal the alibi ruling. He would appeal the alternate perpetrator ruling. He would appeal every decision the judge made until now and whatever decisions were made during trial, and appeal all of that. And all of that's out the window. So everybody can rest easy. You can put the fire out that's on top of your head. He's going to prison for the rest of his life. It's not a problem, but the judge was being very technical, but I don't think he realized the firestorm it would create.
Right, because we were like, wait, what? He accepted a plea deal. He was offered a plea deal, no death penalty, no appeals. And here the judge is talking about, but he can.
Right.
I mean, everybody was completely outraged. And I understand. I mean, the families must also be like, wait, what? So I hope that they're watching your explanation too, because it's very, very helpful.
Well, and if you watch,
you can try, buddy.
Yeah. And if you watch in court too, it's not like the prosecution or anybody lost their mind. They all kind of know what the judge was talking about. It was just from a bystander's perspective, it just sounded a little concerning because we thought that was the whole point, was that he doesn't have the right to appeal. Well, he's waived his right to appeal, but the Supreme Court, and I'll be honest with you, that Garza ruling is a little questionable. It was a split decision by the Supreme Court, but they were basically saying that it doesn't necessarily waive a right. It just means that right is effectively null and void because of the waiver that you've entered into by entering the plea deal. Hope that makes sense.
That makes sense. Right, Grizzlies? You understand as well? I understood. I feel much calmer now.
Good.
Getting a little more. What do you mean? Now, the next big fear people have is, wait, now we're in this interim. We're waiting for him to be sentenced on July 23rd. Right. Can he, from now until then, and even on the day, can he change his mind? Decide to, you know what, I'm going to go back to not guilty. Let's go to trial. Can he do that?
Yes, but it's not that simple. It's a little easier than after sentencing. Like after sentencing, he has to demonstrate either what I said or what's called manifest injustice. So after he gets sentenced, like if, we hear about this with the Innocence Project, right? Where people have 30 years down the line, DNA breakthroughs or whatever else prove that a person was not the person who committed the crime. Well, we're not going to say, well, hey, sorry, that guy took a plea deal and he waived his right to appeal, tough luck, buddy. So in situations where it's like, it would be an extreme miscarriage of justice after the plea, there could be a situation. But again, I'm not trying to concern anyone. That's not going to happen here. But before the plea, before next Wednesday, he does have a little bit more wiggle room, but he still has to show and demonstrate that something went wrong. In other words, he didn't understand. He didn't really know what all the consequences were. His attorney didn't share with him the consequences, didn't share with him all of the defenses that he still had available to him, all of that kind of stuff. Even if that was done, though, I mean, this is important to keep in mind. We go back to right where we were. He's going to go to trial and he's going to face the death penalty. So it's not like he can somehow trick us all out of the death penalty. If he withdraws his plea before Wednesday, which again is highly unlikely, all that happens is the judge goes, okay, great. I'll see you all back here in 60 days and we'll start picking a jury and you're going to be facing a death penalty. So, here we go. Game on. He's, the only one who would lose in that situation would be him.
Yeah, and then some might know, all of us know, wow, you already pleaded guilty, though.
Yeah, right.
That will not be in his favor.
Right.
But some people have speculated, what if this would be like a stunt to get Ann Taylor the delay that she wanted? I don't really see that, but I mean, it's a good question to ask.
Somebody asked me, is this like, next level 3D chess by Ann Taylor to get the death penalty removed? And no, it's not. It's again, even if he were able to convince a judge that somehow there's some compelling reason to allow him to withdraw his plea, like if he goes into court and says, I've changed my mind, no dice. Judge is going to say, sorry, that's not the way it works. He has to go into court and say something like, wait a minute, I was drunk the day that we took my plea, or I was hallucinating, or my attorneys never explained to me that they had an expert witness to explain my cell phone evidence or something like that, then maybe, and it's still in the judge's discretion, he could say, fine, I'll allow you to withdraw your plea. But that would be the shortest lived victory of all time, because immediately, like I said, death penalty's right back on the table. We're heading back to trial. He hasn't gained any advantage whatsoever. Okay,
that makes sense. And here's maybe a silly question but I do see it being asked, so I do want to ask it. Is he now considered convicted, or is it only after his sentence that he's considered convicted?
That's such a great question. I explain this to clients of mine all the time. Two things have to happen for you to be convicted of a crime. You have to plead guilty or no contest or whatever it is, and you have to be sentenced. So he will be convicted. It will go down on his criminal record, on his rap sheet. It will be a rap sheet showing a conviction for 4 murders and a residential burglary after the 23rd. So right now there is this kind of in between period where he's just a person who's pled guilty but not been sentenced.
That's a little scary, because he allegedly said he's eager to be exonerated. Now, that would not mean exoneration, but if something were to happen to him before then, you know what I mean? Then he could.
Oh, you're saying like the Aaron Hernandez type situation? Is that what you're talking about?
Yeah. Like if he could terminate himself or something happened to him before he's actually sentenced, that's a gray area that's not so comfortable.
Yeah. I don't. Wow. I hadn't even thought about that.
Because he's a control freak, you know what I mean?
Technically, he would not be a convicted felon until he's sentenced, technically. It's interesting that you bring up that Aaron Hernandez situation, if that was what you're referring to. But Aaron Hernandez was the ex-NFL player who was convicted of murder. And while his appeals were pending, he committed self-harm and ended himself. And the court in Massachusetts actually vacated his conviction, and everybody lost their minds and thought, oh, wow, what kind of a trick is this that he's now, not a convicted felon? Well, what they don't know is then the Massachusetts Supreme Court went back later, because there was a law in the books that said that. They went back later and they said, this law is not in accordance with our modern understanding of how the law works, and they reestablished his conviction. So he did not have the last laugh, and I imagine there's something in place in Idaho that says the same thing. But if it's before sentencing, I don't know. That's
right.
That's a good law school question. I'm not sure.
Right, I like to risk assess. Yeah, and I'm just thinking, oh man, if he really wants control in the last word and to just leave things up in the air, oh dear. Yeah. Let's hope that doesn't happen. Let's get to sentencing, please.
Yeah, right.
Everybody remain calm and get to sentencing. Nothing must happen to him and all of that. So I wonder if he'll make a statement as well. Many people ask, even in the chat now, do you think that the judge would like grill him, interrogate him, ask him questions, make him answer things at sentencing?
No, I mean, he doesn't, other than what he's already said, he is not required to say anything else again. I mean, there's a very good possibility that the words guilty and yes that we heard him say in court are the last times we will ever hear him speak. But at sentencing hearings, many times the judge will allow the defendant to make a statement. Most of those situations, most sentencing hearings have to do with the judge making a decision, right? It's the person is looking at a range of, 10 to 25 years. And so you'll hear from the victims to say why they feel this person should get the max. And you'll hear from the defendant, some defendant's family sometimes, and even the defendant to say, I'm so sorry. This was the worst mistake I ever made in my whole life, to try to get some mercy out of the judge. Those same kind of concerns are not at play here, because it's already an established thing, what he's going to plead to and what he's going to be sentenced to. But I could see the judge, if he requests to make a statement, I don't think it would be unheard of to allow him to make some sort of prepared remark or to give some brief statement in court. I feel, though, if that were going to happen, we probably would have heard about it before now. I feel like his attorneys would have brought it up at that last hearing and said, by the way, he wishes to address the court at the next court date. But we haven't heard anything like that.
Right. I'm going to ask one more question. Then I'm going to play the rest of the clips. Then I'm going to let everybody else ask questions. So please get your questions ready. I've already started some of them as well, because we only have Josh for another 20 minutes or so. Okay. So my question is, can Bryan Kohberger, speak to the media before sentencing, now that the gag order has been lifted?
Yeah, he can. He's got a First Amendment right to speak to the media if he wants to. But the question becomes, will the Department of Corrections in Idaho grant him media access? So it's not so much a question of whether or not the judge cannot say, I order you to never speak to the media. He simply cannot take that right away from him, even though he's a convicted felon. But the Department of Corrections can say he doesn't have media permission. And so it may be that they are never granted an actual interview. But I would not be shocked if somewhere down the line, Grizzly True Crime is granted an interview or something like that.
Excuse me. Listen, we don't want to talk to him.
Okay.
Anyone else? No, thank you.
Maybe Dateline does some huge follow-up.
Right. That's where my mind was going. I'm like, ooh, is Keith Morrison in there? Is he in?
I'll tell you this: the media is absolutely going to be making the requests, but whether or not the CDC will allow it, and then it's whether or not he even wants to. He could still say no, he doesn't want to.
Right.
I mean, that's sorry to interrupt, but that's the thing to me is everybody's talking about Bryan Kohberger and, he wanted to control and, he wanted, he wants to have the last say in all of this. That's why it's so shocking to me, because I agree with everyone's assessment of kind of his psyche and personality and narcissism and everything else. But to me, that's exactly the kind of person who wants to go to trial, and knowing it's going to be one of the most viewed trials in the last 20, 30 years. Why wouldn't he want that to all play out? And the fact that he took this plea is still shocking to me.
Right. And not to go too much down the OCD, obsessive compulsive disorder rabbit hole, but he was diagnosed with that. And sometimes I wonder if he was just, because then it would be obsessing over even his own crime. So if he went around and around and realized there's no way out of this, I left the knife sheath, there's literally nothing I can do. Maybe he just got to the end of that logic and just decided, well, I really screwed up.
Sure.
Let's just drop it here. It could be that. I don't know. I'm just speculating now. Let me quickly play these clips that I've still got for us. And I think it's only about 3 minutes left. And then everybody get your questions ready. Barbara, you said you posted your question. I didn't start or see it, so please ask it again. I'll look out for it right now while we play this clip.
And it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to.
I think most people think The families know all the details of the case about everything that has happened, Christy. And that's why it's so important as you sit here today that the gag order has been lifted, because I'm thinking you all know all the details of what happened to your daughter that night, but you were telling me that you actually don't.
No, we don't. We don't know any more than pretty much everybody else. So with this gag order being lifted, it will allow us to know more of what happened to our daughter.
Steve, why do you want to know the details? Some people would say the fact that he's going to plead guilty, that he will be in prison for the rest of his life, that he will never be released. You won't have to go through the trial and hear some of the most gruesome things that you've ever heard. Why do you want to hear the details?
I think by hiding the truth, we're protecting our killers. We have to show the ugliness of what this person did. We're writing our victims' impact statements, and we don't even know what the impact is because they've hid the impact from all of us. I don't want gruesome crime scene photos or blood or gore or anything like that, but I need to know the facts of what, how many times was my daughter stabbed? Was she choked? What happened? And that should be part of our victim's statement. And they're robbing us, and they're protecting the killer still. To this day, they're still protecting a guy.
Who admitted to killing her.
Yeah, it doesn't make any sense to us.
Some damage to her.
Okay, so here is a clip from Drop Dead Series with Ashley Banfield, where Steve Goncalves just shared just a little bit since the gag order's been lifted. That's why I'm showing you guys these clips. They're doing interviews, the families, and just showing what they know. But I was shame. I mean, let me just pause for a second here. I was sad to learn that shame. I think everyone's waiting for now the families can talk. Now they could say everything they know. They don't know either. So they're happy the gag order is being lifted so they can get the discovery now and then hopefully learn what happened to their loved one more than they knew before. So that was important as well. Anything you want to add there, Josh?
Just that, these poor people, it's like the most horrific nightmare of all time, compounded with just the torture of the last close to 3 years. I am so in awe of their bravery and the fact that they're able to put one foot in front of the other and wake up every morning still astonishes me from what they have suffered through. And then, it's the tragedy of losing a child, on top of it being a horrific murder, on top of it now being this kind of media nationwide spectacle. My heart goes out to them so much. So I hope that, like they said, they just still want answers. And I just feel like that's just so awful that they don't have them even to this day. So I hope that they're getting some of those answers soon, and that somehow brings them some smallest degree of comfort.
Right. So just them saying now they can have access to the discovery of the case. So the family could get access to some of the evidence before the public, right? The public, we'd have to make FOIA requests, Freedom of Information Act requests. They can now get the discovery and learn some information. Did I understand that correctly?
They can, the sealing orders deal with court documents, what the court has in their possession. But the evidence, like when you talk about discovery, that means like the evidence, the police reports, the photographs, videotape, audio tape of interviews, that is all still in police custody. And that is something that has to be requested through FOIA requests or Public Records Act or what have you.
Okay, let me quickly play this clip from some new information that Steve had shared on Ashley's show.
Some damage around her mouth right here, like somebody had pressed in and tried to keep her quiet. She'd been hit multiple times in her head, and her skull was damaged.
Lifting the gag order, Shannon, you say is important too. Why? Because, they know some of the details, but I'm surprised to hear they don't know all the details.
Well, it's a couple of things. You obviously, the discovery in the case, right? We now could have access to the discovery in the case. We already had a meeting with the prosecutor's office in this case and asked them for a copy of the discovery.
And giving you the discovery would do what?
Police reports, the university, or it's Idaho State Police, Moscow Police Department, the FBI, all have investigative reports, the investigation that was done, photographs, pictures, all of those things that are part of the discovery gives us an opportunity to find some answers that they don't have right now. And then you also have the court, all the filings with the court that can be unsealed. We obviously know that most of that stuff will be redacted to protect the information of those privileged, which it should. But all of that information is very important, and it's important that the prosecution keeps their promise to the victim's family and gives them a copy of that discovery. But because if you have to go through the normal course, you do public records requests through all the agencies, and it could take years to get all that information.
So that's what you said. Okay, let's bring us close again. Okay, everyone, we've got 10 minutes left with Josh. I'm going to rapid fire some of these. Okay, so let's see. Ryan Wimmer said, without the DNA on the sheet, there is no trial. Therefore, that is the only significant evidence. One expert casting doubt on touch DNA, he walks. Plea was the obvious choice. Why pretend the case was so great? Any comments there?
Well, I agree with Ryan. Thank you for the comment. I agree with you that the DNA sheath, I think the case rose and fell on that. I don't think without the DNA that they would have even filed it, but I would say that that there was far other evidence supporting that DNA. I mean, the fact that they've got that the same person whose DNA there happens to drive the same type of vehicle that they were looking for, that he happens to have been in that area 23 times in the past, that he happens to have turned off his phone during the time of the murders, that, you can go on and on and on of things that make it remarkable that that same person whose DNA was located there is also the same person that matches all these other lack of alibi type things. So to say that casting any doubt, the case would have fallen apart. But if they had kicked it out before time, or if they had completely, decimated the trustworthiness of it in court, then I agree that there could have been some major problems.
Right. Thank you so much, Ryan, for the sticker. Thank you, everyone, for the stickers, and happy Grizzly-versary to your membership milestones as well. I see lots of people are celebrating that today as well. Kraken said, do you think the leaked info query will continue?
That's a great question, too. I think it will, because I think the judge and the law enforcement is probably still very bothered as to who that was. They still have to kind of address the problems in their own ranks, if it was law enforcement, and figure out who that was. So if they're able to figure it out, I think they're going to still try to.
This is a similar question. Thank you, Kuba, forever. So I think you answered, will the lifting of the non-dissemination order have any bearing to the ongoing investigation by the special prosecutor into who leaked information to Dateline? Thanks, and keep up the great coverage. Thank you so much for your sticker. So I think we answered that, right?
Yeah, except the non-dissemination order is going to have really no effect on the special prosecutor that would have had access to all of the discovery and information anyways. The non-dissemination just really has to do with the parties and the media.
Okay. And Rainy Day said, saw you on, is that Courtroom Confidential? That's your channel.
Hoping,
and love your input over there. Wanted to send you some peace, love, and happiness to you and your crew. Is it for me? Is it for us? Thank you so much, Rainy Day. Jonah Moore said, what's the difference between sealed and redacted?
Sealed means just not released at all. It's just completely kept under lock and key. Redacted means it's released, but they edit out certain information. So maybe the names and addresses and, other identifying information, but they release the rest of the document. Yes.
Or even the videos. Sometimes they'll just put a black block or a redacted block over body cam videos. Also, I wanted to mention earlier, people mustn't get excited that we're going to see like police video interviews, because Kohberger lawyered up immediately. He didn't talk.
No.
So we can't be too excited about interrogations coming our way. CH said, can Josh speak to what is allowed and not allowed in victim impact statements?
It's very broad. I mean, there's no rules about it. It's kind of an opportunity for these people to have their voice heard. So sometimes you hear people carry on for quite a bit of time, and they are kind of venting their frustrations and their anger. And, lots of times it involves tears. Sometimes it involves cursing. The judges usually give fairly wide latitude to the victims during these impact statements. I'm trying to think of a time I've ever even seen a judge cut it off. And I can't really think of it. They're kind of given free rein.
Right. So somebody asked, and I guess it would apply to anyone making statements, could anyone be removed from court if they get out of hand?
Yeah. I mean, we've seen situations where people have tried to jump the partition and go after the defendant, or if they're screaming and causing a real commotion in court, the judge is always going to get involved. I have heard, and I'm not sure, maybe you know more about this, that the Goncalves family plans on being there, but Steve may still not enter the courtroom. I'm not sure.
Interesting. Yeah, he was also saying one of his kids is going off to college and is conflicting with that, so he doesn't even know if he'll be there and even make any statements. But
Oh, wow.
that Kaylee's sisters would like to make statements, and he just finds it sad that they don't have any, like, all the information they want to explain the impact when they don't know the impact because they don't have all the information. So
Right.
yeah, thank you, Karen. Thank you, Sophia. Thanks everyone for the stickers. Bibo Mora said, thank you for breaking all this down. Greatly appreciated. Love both your channels and much love and respect to all the mods. Thank you so much. Alexis North said, Josh's opinion or thoughts on the idea that BK pled on the request of his dad or family who was reported having spent some time with BK the days before. Sounds like the only motivation for BK, in my opinion.
Yeah, I've heard this a lot too, that his family may have weighed in and said, listen, it's time to avoid this further kind of trauma to the family, avoid the death penalty. I will say that in my view, the interesting timing of it is that he lost the alternate perpetrator argument. And to me, that was their last chance of having any kind of affirmative defense. And when they lost that, I think they turned to him, his defense, maybe his family, and said, what are we doing here, Bryan? You're going to trial. You're likely going to lose, and you will very likely be sentenced to death. So what do you want to do?
Yeah, I think the combination of losing that battle with the alternate perpetrators, then the Pennsylvania hearings, and some people saying they absolutely don't want to testify. Nobody's going to try to save his life over there. That was another loss, essentially. And then, yeah, maybe his dad spoke to him as well. Elena says, G and Josh, do you agree with the Goncalves sentiments? I mean, I do. I feel for them. I feel great empathy for them. And I understand the outrage. How about you?
Completely. I give these people space to feel however they want to feel about it. If I were, I can't even go through the thought of experiment of trying to place myself in their position. But if I were, I probably would be just as furious and outraged and still upset. So they can grieve and handle this however they want, in my view.
I agree. Okay, so last question. What have you got going on your channel? Coming up, what's the next thing?
Oh, thank you so much. Thank you so much for having me. Thank you, everybody, for being here in the chat, being so kind and asking such great questions. Yeah, check out Courtroom Confidential. Tomorrow, we are releasing what we call our weekly roundup. We do it every Saturday. There they are. And it's just kind of a 30-minute catch up on everything that happened that week, if you guys didn't have the time to follow all these cases. And then Sunday is the fun thing. And Gisela asked a question last time.
I did.
And
it's time-stamped. I like your timestamps. Right at the end.
She's in the chat fairly often. Yeah. And if you go to thecourtroomconfidential.com, you can click on a button that allows you to leave a voice message. And then we take all the voice messages that were left through the week and I answer them live on Sunday mornings. It's at 9 a.m. Pacific, noon Eastern. And we just take a couple of hours to go through all of them. And it's fantastic because you wouldn't believe, yeah, there it is. You click on that button there to the right. Everybody comes up with the best questions. You get all these great random questions about old cases and new ways to thinking about them. And it's just become really fun. And we put people on the map wherever they are in the world. And
Yes.
it's a fun time.
I saw that's some great map time as well. So if you guys want to send a message, if we didn't get to your questions today, well, shame. I don't know if a flood of people, 4,100 people, Josh, they're gonna
Oh yeah,
they're gonna leave a voice
Send
message
them all. Yeah,
right here.
We'll take them. Send us the questions.
Right. So either you can leave a voice message if you want, or go to Josh's channel and click notify me on this upcoming. Let's see, did I click it yet? Look there. We could do it now. Notify me. There's already somebody there and needs to join your membership. So click notify me, and then you can join in on the chat because you also answer questions that way during your Sunday streams too. So it's great as well, especially, as I say, for anyone upset that we didn't get to your questions, I'm so sorry. There's lots of people here and I would have loved to. Leave some questions in the comments below as well. Josh, if you feel like being in our comment section, feel free to answer them there.
I will.
Maybe even Tiffany T. Suze will be there, your wife, helping us out, and we will definitely be there in your chat. So now we're just about done with the stream. I told you I won't go over the hour.
Oh, you're perfect. The time is impeccable.
And I appreciate you so much being here. Thank you so much. I hope that we can always call on you because I really like your insight and experience, and it helps us all understand. I will see you all again very soon as well. Thank you, Josh, for being here. Everyone, happy weekend. Bye.